Connecting contract creation to what you already know. In the previous section, you learned what makes a contract valid, void, voidable, or unenforceable. You saw that every real estate agreement depends on competent parties, mutual consent, consideration, lawful purpose, and voluntary, good faith action. Now we turn to the next logical question. How is that contract actually created in real life? In a real estate transaction, the movement from "we're interested" to "we have a binding contract" happens through offer and acceptance. This process sounds simple, but it is surrounded by legal rules about timing, communication, counteroffers, revocation, and who is allowed to prepare the documents. As a salesperson, you live inside this zone every day. Understanding contract creation at a deeper level helps you explain negotiations to your clients, avoid careless mistakes, and recognize when you may be stepping into the practice of law instead of real estate.
Offer and acceptance in real estate, mutual consent, or meeting of the minds, is achieved through offer and acceptance. One party, the offerer, proposes specific terms. The other party, the offeree, either accepts those exact terms or rejects them. When the offeree accepts all terms without change, and that acceptance is properly communicated, the offer becomes a contract. In a real estate sale, a buyer typically becomes the offerer by writing and signing a purchase offer that identifies the property, price, closing date, contingencies, and other important terms. The seller is the offeree and has the power to accept, reject, or counter. The key moment is not when someone likes the deal verbally, but when the offeree communicates a clear acceptance back to the offerer. Until that communication occurs, there is no contract, only an offer on the table. Writing and communicating the offer.
In real estate, the offer must be in writing to be enforceable because of the statute of frauds. A well-drafted offer clearly describes the property, the purchase price, how and when funds will be paid, the closing date, contingencies such as financing or inspections, and any personal property to be included. The offer must be delivered to the offeree or the offeree's authorized agent to be legally effective. Many offers also include a "time is of the essence" clause with an expiration date and time. When that clause is present, the offer expires exactly at the stated time, if not accepted. If no expiration is stated, the law allows a reasonable time for acceptance. But what counts as reasonable can depend on market conditions and the nature of the property. A hot market may make a few hours reasonable. A complex commercial deal may justify more time. Acceptance and the mirror image rule. Acceptance is the offeree's clear and unequivocal agreement to all terms of the offer. Under the mirror image rule, acceptance must mirror the offer exactly. Any change to any term, even something that seems minor, is not an acceptance, but a counteroffer. In real estate practice, acceptance is usually shown by the offeree signing the offer without changes and dating the signature. That signed document must then be communicated back to the offerer or the offerer's agent. If acceptance is communicated by mail, many courts follow a version of the mailbox rule. Acceptance becomes effective once it is properly placed in the mail, not when it is received, assuming the parties contemplated that method. With modern technology, email and electronic signatures often serve the same function, though specific state laws and court decisions will determine how the mailbox rule applies to electronic communication. The important point for you as a salesperson is that acceptance is not complete until it is both given and communicated. Imagine a buyer offers to purchase a home for a set price, with a 10-day inspection period and a specific closing date. The seller signs the offer without altering any terms, and the listing agent sends the fully signed document back to the buyer's agent by email before the expiration time. At that moment, assuming all other elements of contract validity are present, the parties have a binding contract. If the seller had changed even a single date or dollar amount, that would not be acceptance under the mirror image rule. Counteroffers and the negotiation dance. A counteroffer is created whenever the offeree changes any term of the original offer. Legally, this is not a variation of acceptance. It is a rejection of the original offer and the creation of a new offer. The roles reverse. The original offerer becomes the offeree, and the party making the counteroffer becomes the new offerer. For example, a buyer offers $450,000 with a 30-day close. The seller signs the contract but changes the price to $460,000 and pushes the closing out to 45 days. By making these changes, the seller has rejected the buyer's original offer and created a counteroffer. The buyer is no longer bound by the first offer and now has the power to accept, reject, or counter again. Real estate negotiations often move through several rounds of counteroffers. Legally, there is still no contract until the final counter is accepted without change, and that acceptance is communicated. As an agent, it is critical to help clients understand that we're close does not equal we're under contract. Only the last set of terms agreed to and signed by both sides, with proper communication, creates a binding agreement. Revocation and other ways an offer ends. An offer does not last forever. Several events can terminate an offer before acceptance. First, the offerer can revoke or withdraw the offer at any time before acceptance is communicated, even if the offer has not yet expired. For example, a buyer submits an offer in the morning, but a sudden job loss in the afternoon makes the purchase impossible. The buyer may call their agent and revoke the offer, as long as the seller has not yet accepted and communicated that acceptance. Once revocation is communicated, the offer is extinguished and cannot be accepted. Second, the offeree can reject the offer outright, verbally or in writing. Once rejected, that particular offer is dead. A subsequent, "I changed my mind, I'll take it," is actually a new offer. Third, a counteroffer by the offeree automatically terminates the original offer because a counteroffer is a form of rejection. Fourth, an offer may lapse if its stated expiration time passes, or if no time is stated after a reasonable period. Finally, the death or legal insanity of either party before acceptance will terminate the offer, because there is no longer a competent party to contract. All of these rules remind you that offer and acceptance is a living process, not a frozen moment. Options and the loss of the right to revoke. Sometimes a party pays consideration for the right to keep an offer open for a specified period. This creates an option. In an option agreement, the optionor, usually the seller, promises not to revoke the offer during the option period in exchange for option money paid by the optionee, usually the potential buyer. During that period, the seller cannot revoke the option, even though they could ordinarily revoke a regular offer. If the buyer exercises the option within the time period, a binding purchase contract is formed on the agreed upon terms. Options are common in commercial real estate, land development, and lease option arrangements. Assignment of contracts. Some contracts can be assigned to another party, others cannot. Assignment means that one party, the assigner, transfers their contract rights and benefits to a new party, the assignee. In real estate, sales contracts are generally assignable unless the contract specifically prohibits assignment, or the agreement is so personal in nature that assignment would change the bargain. An investor might put a property under contract and later assign that purchase contract to another buyer for a fee, as long as the contract allows it. In contrast, personal service contracts, such as listing agreements, are not assignable. A seller hires a particular brokerage and agent for their skill, reputation, and relationship. That personal professional service cannot be handed off to someone else without the client's consent. As a salesperson, you must read each contract carefully to see whether assignment is permitted. If your client wants to assign rights, such as a buyer in a new construction contract, you should look for assignment language, and when in doubt, suggest that the client seek legal advice or an addendum from the builder. Contract preparation and the licensee's role. State law determines how far real estate licensees may go in preparing contracts. In many jurisdictions, brokers and agents are allowed to fill in the blanks on approved, pre-printed contract forms, but are not allowed to draft custom legal language. They are also not allowed to give legal advice. This balance is sometimes called a broker-lawyer accord. Lawyers draft the forms and handle complex legal matters, while brokers and agents use those forms to facilitate routine transactions. In Arizona, Article 26 of the Arizona Constitution gives licensed, active brokers and salespersons the right to prepare instruments incident to real estate transactions handled by their brokerage without charging a separate fee for document preparation. This includes documents such as purchase agreements, earnest money receipts, deeds, leases, and contracts for the sale of real estate. However, that authority does not convert a licensee into an attorney. Arizona licensees still may not give legal opinions or draft outside the scope of real estate transaction documents. They must also comply with Arizona's statute of frauds, which requires that real estate contracts be in writing to be enforceable. The practical lesson is that you are allowed to prepare and complete standard real estate forms in transactions your brokerage is handling, but you must stay within those boundaries. When a client asks for a custom clause with important legal consequences or wants advice about rights and remedies beyond the contract language, your best response is to recommend consultation with an attorney. Binding elements and the mailbox rule in practice offer, acceptance, and consideration are the three classic binding elements of a contract. Offer is the clear proposal. Acceptance is the offeree's unqualified agreement to the exact terms. Consideration is the value exchanged to support those promises. Real estate transactions add additional elements, such as the requirement that the contract be in writing, identify the property, and be signed by the parties. Acceptance can be expressed in several ways: by signing and returning a written offer, by signing a counteroffer, or by performing in a manner clearly contemplated by the offer. The mailbox rule generally states that when the parties contemplate acceptance by mail, an acceptance becomes effective once properly mailed, even if it has not yet been received. With the rise of email and electronic signatures, courts have gradually adapted the concept to electronic communication. In many real estate transactions, email delivery of signed documents is treated as effective communication of acceptance once the message is successfully sent to the correct address, depending on the contract language and local law. As a salesperson, it is wise to follow brokerage policy and contract instructions on how and when offers and acceptances are to be delivered, and to document that delivery clearly. Arizona licensees and contract-related duties. Arizona law adds another layer to contract creation in practice. Only licensed, active salespeople and brokers may assist the public in the sale, purchase, lease, rental, or exchange of real property for compensation, and their licenses must be current and active. They must comply with rules on advertising, compensation, handling of trust funds, record keeping, and agency relationships. For example, Arizona license law requires that certain records be retained for at least 3 years, and that client funds be properly handled in trust or escrow accounts. These rules support the integrity of the contracts you help create. Offers, acceptances, escrow instructions, and closing documents all depend on accurate records, honest advertising, and proper handling of money. At the same time, licensees may not misrepresent terms in contracts or in advertisements. False or misleading statements about property or about contract terms can expose a licensee to disciplinary action and civil liability. Understanding contract creation is therefore not just a matter of academic law, it is a daily risk management tool for your license and your client's interests. Review summary. This section showed you how a real estate contract is actually created. You learned that mutual consent is reached through the process of offer and acceptance. A written offer must clearly state all essential terms and be communicated to the offeree. Acceptance must mirror the offer exactly, and be communicated back to the offerer. Any change to the terms creates a counteroffer, which kills the original offer and reverses the roles of offerer and offeree. Offers can end in several ways, including revocation, rejection, counteroffer, expiration, and the death or insanity of a party before acceptance. You saw how an option agreement uses consideration to remove the offerer's usual right to revoke during the option period. You learned that some contracts can be assigned, while personal service contracts like listings cannot. You explored the limits on contract preparation by real estate licensees and saw how Arizona's constitution allows brokers and agents to prepare transaction documents in matters handled by their brokerage, but without charging a separate document preparation fee and without giving legal advice. You also reviewed the binding elements of offer, acceptance, and consideration, and how the mailbox rule can make acceptance effective when mailed or electronically delivered, depending on the agreement and local law. Finally, you saw how Arizona licensing rules on writing requirements, advertising, compensation, record keeping, and handling of funds support contract creation and protect consumers. Together, these ideas give you a complete picture of how a real estate agreement moves from interest to a binding contract. Discussion. Why is it so important for a real estate professional to keep track of exactly when and how an offer is accepted and communicated? Suggested answer. The moment of acceptance and communication is the point at which a binding contract is formed. Knowing exactly when and how acceptance occurred determines whether the offer was still open, whether a revocation was effective, whether competing offers were valid, and which party has contractual rights. Precise documentation of acceptance and delivery helps avoid disputes about whether a contract exists and protects both the client and the licensee if questions arise later. How does understanding the difference between an offer and a counteroffer help you manage client expectations during negotiations? Suggested answer. Many clients think that a small change in terms still means we accepted their offer. In reality, any change creates a counteroffer and kills the original offer. Understanding this difference helps you explain to clients that there is no contract until the last version is signed without changes and communicated. It also helps you warn clients that by countering, they may lose the first offer altogether if the other party walks away or accepts a different offer. This understanding allows clients to make more informed strategic decisions about when to counter and when to accept. Closing remarks. Contract creation is the heartbeat of your real estate practice. Every listing, every buyer representation agreement, every purchase contract, every lease, and every counteroffer begins with an offer, and if successful, ends with acceptance. Between those 2 points lies a careful dance of communication, timing, revocation, and counteroffers, all governed by contract law and state-specific rules, like Arizona's Statute of Frauds and Article 26. By mastering how contracts are created, when offers terminate, what assignment means, and what your legal role is in preparing documents, you position yourself as a knowledgeable guide for your clients. In the next sections, you will apply these concepts to specific real estate forms and clauses. But the principles you have learned here will remain the foundation for every transaction you handle.